Good morning, everyone. For this second roundtable of the day, I am very delighted to welcome some friends of mine who, as practitioners, will share their view on the maritime risk and, in particular, the ever-given case. So let me introduce you the participant of this discussion. The first participant is Janine Ramirez Estrada from Mexico. She's a legal counsel at APM Terminals. APM Terminals operate one of the world's most comprehensive port network owned by Maersk. Janine is responsible for all legal matters of APM Terminals in Mexico, including major litigation as well as claims for damages caused to the third parties such as cargo and vessel damages. The second participant is Carl de Piper from Belgium. He fully qualified as a lawyer at the Antwerp Bar, specializing in maritime and transport litigation. Currently, he's working as average agent and loss adjuster at Atlantis International Services, dealing with general averages and casualty response. The third participant is Ettore Violante from Italy. He's a lawyer at Piccinini Partners in Genoa. In his firm, he cooperates with the shipping team on P&I matters and transport disputes, and cooperates also with the insurance team on the third-party and professional liability litigation. And finally, we have Masaki Sasaki from Japan. He is a partner in the shipping team at TMI Associates. He works mainly on shipping disputes resolution, including charter parties, bill of lading, insurance, and shipbuilding. The discussion will be led by Raphael Vianna from Brazil. He is a professor and lawyer. He is also vice president of Rio de Janeiro Chamber of Maritime Arbitration. Raphael, it's all yours. Raphael.
I think we missed Raphael.
Non, Raphaël, ton microphone.
D'accord.
Open your mic, Raphael.
I'm sorry. Good morning, everyone. I'd like to thank the organizers of this international webinar that brings together professionals from different branches of maritime transport and from different countries, which favors the discussion around comparative law. It is a pleasure and a great happiness to be amongst good old friends from France. Mes chers amis Dominique Gaurier, Franz Minard, Frédéric Devanson, Hama El Tayeb El Sadig, Aurélien Tillet, and having also the opportunity to make other friends during this webinar, even though we're still separated by at least 8,000 kilometers. I'm not considering Brazil and Japan. I'm considering Brazil and France. It is an honor to finally meet Professor Martin Dendé, director of the Center for Maritime and Oceanic Law, where I spent a pleasant 2 years of postdoctoral studies under the coordination of the former director, Professor Patrick Chomet. On the subject of our webinar, as Professor Christian Escapel used to say, insurance is the very condition of maritime trade. Insurance is essential for the ship owner due to the high risks taken. Insurance is not less essential for shippers. See the limitation of liability and the cases of exclusion of liability. As we will see, and the ever given case will demonstrate, insurance is a condition due to the large financial impact that a major accident can cause. I will just moderate this panel along with my friend Hama, but the estimated panelists will be Ms. Janine Ramirez from Mexico, who will bring more details about the terminal's point of view, Mr. Masaki Sasaki, who will give us Japanese and international lawyer point of view, Mr. Ettore Violante, who will bring us the Italian and international lawyer point of view, and Mr. Cole De Pipere, I hope it's like this, De Pipere, who will present us with the lost and average adjusted point of view. So the first topic we'll be talking about will be giant vessels, concentration of risks, concentration of huge quantities of goods, and who takes advantage with the increasing growth of ships, shippers or ship owners, or both. So I'm gonna go by topics, and after presenting the topic, I will ask each of the speakers to present their point of view, okay? So let's start with Ms. Tiani.
Okay, thanks. Well, first of all, I want to thank you for inviting me to this webinar. It's a pleasure to be here. And well, starting with your question, well, it's a fact that nowadays container ships need or have to meet very tight hours, and they need to be as loaded as possible. So as a result of this, the ships need to increase or to invest in powerful engines. So this will lead us to a very, very important and one of the main principal duties of the ship owners, that is to provide a seaworthy ship or a seaworthy vessel. So I will say that here we can find one of the risks that it will be for the ship owners, because the vessel that they have must have a degree of fitness for these new maritime or for these maritime adventures. In addition, I will say that since nowadays we have many shipping lines, and of course they want to be competitive, they take some measures such as reducing the number of crew members, let's say, or this is just an example. But this will also lead us to another risk, that it could be the unseaworthiness. Let's remember that one of the factors of the unseaworthiness is an incompetent crew, or a crew which is insufficiently instructed or insufficient in numbers. So here we can find two risks that are concentrated in the ship owners. On the other hand, if we analyze the contract of carriage, the bill of lading, a cargo claim can be brought to the carrier, either the ship owner or the carrier. And after that, the carrier may then seek to recover an indemnity under the terms of the charter. And here, unless it is specified in a different way, time charters clauses transfers the responsibility to the charter. So here we can find another risk, or we can face another risk for the for the charter. But let's remember as well that liability will remain on the ship owners in some circumstances. For instance, the intervention of the master in any decision. So this is just some of the examples that will lead us to the situation of giant vessels. Here we have risks for both. I wouldn't say that the shipper or the ship owner takes advantage of this scenario. I think this will bring more risks for both parties. And of course, here maybe Carl will help us. This will mean also a challenge for the insurance companies, because definitely the risk will increase in these maritime operations where more TUs are loaded in giant vessels.
Can I add to that?
Yes, for sure.
Yes, I think indeed that the bigger the vessel, the bigger the risks, that may be a simplified principle, but I think there's also a third entity that suffers risks due to the scale of the vessels and the scale augmenting of the vessels, because you have a cargo side, you have a ship owner side, and those are actors in the private market. And what you see lately is a race to the bottom when it comes to prices. So the bigger the ships, the more cargo they can carry, the more they can basically put pressure on pricing. But those bigger ships also imply operational risks, not only for ship owners, not only for cargo owners, but also for public authorities. The best example I can give you, and related to the Ever Given, is, for example, the Suez Canal authorities. They basically suffer risks because they have to let ships which are bigger and bigger and bigger through their canal, and when it goes wrong badly, and the consequences are huge. Maybe the bigger the risk, the bigger the ship, the bigger the consequences. But apart from that, when you look at the private actors, the shippers and the ship owners, I think ship owners suffer risks because the bigger their ships, the bigger the operational risks are, but also cargo owners, because when you have 2 or 3 containers on a vessel that has 20,000 containers, you're basically in a pool of cargo interests, and with insurers backing those cargo interests. And when something serious happens, you often have to look at the ship owner, but you have to do so in a very scattered landscape. So when you have cargo owners, there's basically 10,000 different parties with an interest on board of one ship who have to look at one ship owner. Claims management for ship owners must be a nightmare. And the bigger the ship, the bigger the nightmare, I think, the longer the night. But when you have 10,000 different bills of lading or 20,000 different bills of lading, it's almost impossible to manage a casualty like the Ever Given. And I think that means a risk as well, because when you have a container with a value on board of, let's say, 15,000 US dollars, or you have a break bulk ship, for example, with one cargo interest who has the ship fully laden, it's much easier to basically litigate, to basically assess the risk. And if you're not like settling between ship owner or a charterer and cargo interest, it's easy to go bring that matter before a court. You have a certainty of justice, or at least a degree of certainty that you can bring your cargo claim or your claim before a court. But for one container with a value of 15,000 US dollars, you will not do that. That will simply not happen. That's a matter of principle, and principles cost money, and insurers don't really like things costing money. So I think part of the scale up, and also a consequence of containerization, is that risk for cargo insurers becomes a bit bigger because you have a much more scattered landscape on board of the ship.
I would like to join also Carl's consideration. Is it true that the insurance market can be badly affected about this mega ship? Because the risk is massive. If you think, apart from the Ever Given, think about the Costa Concordia, because we have mega ship not only for cargo, but also for passengers. For instance, another casualty that happened in 2018 was the fire on board, I think the Maersk Onam, something like that. So this one is going to reflect really badly on insurance premium, or maybe other underwriters, they are not willing to cover, to take the risk for mega vessel. So that one is going to be a really, especially for the Ever Given case, a really great massive effect of the insurance market, not only for the cargo, but also for the alley machinery and the P&I club as well. So I would like to ask a question to Janine about the infrastructures, because if you think mega vessels need a really logistic structure, as well as the capability of the dock and ports to let this vessel navigate. So for instance, in Italy, we had a couple of ports that are capable to handle this, such as Gioia Tauro. But what about the Panama Channel? Are they planning to, for instance, to improve their structure to avoid an issue such as the Ever Given? Do you know about that, Janine?
That's a really good question, Ettore, and I think this is one of the main challenges for these big vessels, because they need to make sure that the port that they will call has all this infrastructure that it is necessary to attend these vessels. For sure, as a port operator, these giant vessels mean more infrastructure, and of course, for example, the STS that you need to discharge or to unload the vessels, definitely it's something that should be considered, or that should be taken into account by the vessels. They need to consider, and this is another very important point, that is the safety of the port for these vessels, and one of the relevant matters is this infrastructure that is needed to attend these vessels. So for sure, this is one of the main challenges that these giant vessels face. And of course, the port operators need to have all the needed infrastructure for this. Yes.
Thank you.
Just a brief comment from a lawyer's perspective. Of course, a giant vessel have a lot of benefits for cargo owners, but ship owners, it bears big risk, especially the super ship will make the matter very complicated, and it will take considerable time to resolve the legal proceedings, such as limitation proceedings and the GA process. From my experience, it took 5 years or 10 years to complete. Yeah, it's just terrible for ship owners. This is just my personal opinion.
Janine, I have a question. We know that the shippings are increasingly growing. And what about the ports, the terminals? Are they arranging? Because I heard we will have to construct deep water ports to be able to receive this kind of ships. What do you think about this?
Yes, I can say that nowadays port operators are investing in their terminals. They are modernizing the infrastructure that they currently have to meet all the current market. From this side, I can say that at least APM Terminals is doing great in this regard, because we are acquiring all this equipment that is necessary to meet the market requirements. So of course, the competition is there, and therefore I can say that that port operators are trying to suit their terminals to receive these vessels. Of course, this means investment for the not only for the equipment, but as you say, to know where to invest, to know the physical characteristics of the port to receive these vessels. So this is also a challenge for us, where it is better to have a concession agreement where it works like that, and that it will be rentable for the shipping lines to receive these vessels. So this also, at the same, this also means a challenge for us as a terminal operators to know what ports will be better to attend the current market. Yes.
Okay, let's move to the second topic. Or
I
do you have something to...
I maybe have a small addition. This can be used as a bargaining chip between countries as well. If you look at the port of Antwerp, for example, is one of the largest ports in Europe. Huge vessels are mainly container vessels, and the port of Antwerp is, after Rotterdam, the biggest container terminal in Europe. But you see, there's quite some competition between Rotterdam and Antwerp, but the entrance to the port of Antwerp goes through Dutch territory. And if Dutch authorities basically want to gain a competitive advantage for Rotterdam over Antwerp, they can basically choose not to maintain the Westerschelde Canal, because the sea and the port of Antwerp are connected through the Westerschelde, the river Schelde. And if the Dutch authorities don't maintain that river, it's impossible for tall ships to get, or large ships to get into the port. So that's basically also a bit of friction and economic, that can be used as an economic bargaining chip due to the scale up of the vessels. That's my small addition to that point.
It's a good point of view. Let's move to the second point. How do you see the importance of cargo insurance faced with, we saw that the ship owners, the insurance is essential for ship owners due to the high risks taken. So for the other side, how do you see the importance of cargo insurance faced with limitation of liability, exclusion of liability, and also within this topic, can the pilot be liable for damages caused by a ship? So let me make the question again. How do you see the importance of cargo insurance faced with limitation of liability and exclusion of liability? And also within this topic, can the pilot be liable for damages caused by a ship?
Well, I will say that it is really important considering all what we have discussed, because the risk is even bigger. And Carl, if I'm not wrong, just said exactly the same. This is not only a risk for ship owners or for careers. This is also a risk for cargo owners. And let's think in the operational way of the vessel. The more loaded the vessel, the stowage, it might be bigger, maybe, and this will affect the stability of the vessel. So here you have a risk for the cargo owners. So definitely the cargo insurance will play an important role for cargo owners. Regarding the limitation of liability, well, if we consider the provisions of the Hague-Visby rules, well, these rules fall into main two categories: the minimum obligations of the career and the provisions defining the maximum immunities to which he is entitled, to extent to which he can limit his liability. And I'm going to give my point of view from a port terminal operator, and that is the scope of the limitation of liability. And this is very important because we all know that ship owners can limit their liability. But what about terminal operators? Can they also limit their liability? Because it is important to say that the terminal operators are also part of the logistics chain. But are we part of this benefit of limitation of liability? Well, Article 4, Rule 2 of the habeas rules provides that a servant or agent of the carrier can rely on this provision. But it is clear to say that independent contractors cannot be benefited from this limitation of liability. Therefore, as a port operators, at first instance, we cannot rely on this limitation of liability figure. However, and to be honest, and from my point of view, there is no logical reason or commercial reason for this, because at the end, as I said, we're part of the logistics chain. We are part of this operation. However, there are two possible ways, and we emphasize this with the carriers, that we ask for the inclusion in the contract of carriage of the Himalaya clause. Then, in this way, the independent contractor, the stevedores that carry out the operations in the port, can require the carrier that is specifically made a party of the contract of carriage. So this is a very important point, and I think the terminal port operators should also be considered for this benefit of limitation of liability.
So I will say that cargo insurance and unmanned machinery are actually first player in accident like this, because for instance, P&I insurance is a second risk insurance. So the cargo insurance and the land and machinery will actually benefit from the limitation of the liability of the owner. So regarding the claim, cargo insurance will cover, of course, the damage to the goods. But different is for delay, because if you think many cargo coverages, such as the Institute Cargo Clause, provide actually an exclusion for delay in delivery. So such type of coverage will provide only for the actual loss or damage to the goods. And for the limitation of liabilities, as I said, the insurers will actually benefit from such a limitation. And they will, of course, contribute to general average. But this one should actually move also for the cargo claim. As Yanin said, the owner can actually limit his liability according to the Hague-Visby rules, and an insurer will actually benefit from that.
I have just a question for Yanin. You asked about the possibility of limiting liability of terminals, and do you think terminals bear the risks of the maritime adventure?
Not really, but it is important to say that, for example, when we are carrying out operations of loading and unloading, we have had situations where we have incidents. However, these incidents are as a result of the conditions of the vessel. For example, sometimes the containers are stowaged, and when we want to unload the container, this is not possible. This is not possible because the twist locks of the containers are not in good circumstances. So this could cause an incident. And of course, here I can argue that the incident was a result of the vessel's situation. But it's important to say, because sometimes it's not that easy to determine when the incident was a result of the vessel conditions. And there are many other reasons where we also bear the risk in the operation. So I think it is important to add this clause, because yes, there are some situations where the terminal bears the risk during this operation, and I don't see any commercial reason for not considering the terminal operators in this limitation of liability figure.
Okay, just to make a point, to be considered a ship it must be a floating engine. It must have ability to face the risks of the sea. It must have autonomy of conduction. It must develop an activity usually at sea. So one of the requisites for to be a ship is ability to face the risks of the sea. And that's why they give limitation, the possibility of limitation of liability, exclusion of liability to shippers, to ship owners. Can I pass to Ettore or Cor or Masaki? Who would like to make a... Ettore?
Can you repeat? Sorry, Raphael, can you repeat the question because my headphone...
No, it was not a question. It's, we were just discussing about the right to have limitation of liability. So Yanni asked about the limitation of liability of terminals. And I said, terminals do not bear the risks of maritime adventure. And that's why they have limitation of liability because of the risk of maritime adventure.
Okay. Now okay, sorry. So I think is the limitation of liability is more a commercial aspect. If you think such kind of limitation, there is not only for ship owners, but also for a road carrier as well. So if you think that the massive risk connected to an accident like the Ever Given and the ship owner cannot limit his liability, that means bankruptcy of the company. That's the same for a road carrier. So we actually need to think, because we are discussing about marine traffic that is a commercial aspect. So limitation of liability is purely a commercial aspect. So we cannot paralyze the traffic. We cannot set up a company, then first accident, bankruptcy, then set up another company. So I think, especially because as Yanin say, okay, terminal cannot limit its liability, but the risk that a terminal bears is not the same of a risk owner, which contain like 20,000 containers on board. That is my point of view. So I think is correct, provides a limitation of liability. In the Italian legislation, we are not party of the limitation of liability convention, but we have in our civil code limitation for the road carrier, and in the navigational code limitation for the maritime carrier.
I will also like to add something, and I see your point, considering that the terminal doesn't bear the risk of the maritime adventure. However, there are other parts, there are other players of the logistics chain that also has this benefit. And I'm talking about land transportation. They can also limit their liability. At least here in Mexico, under Mexican law, they can also limit their liability. So here we have two players, the shipping lines and the land transportation. But in the middle of them, there's also an important player. And as you're saying, this is a commercial reason. What about the terminal operators? And here is my point. We are part of the logistics chain. And as the shipping lines bear the risk of the maritime adventure, yes, but also we have the land transportation with this benefit. But there is something missing there.
So Janine, are you working for the terminal syndicate?
No. But it's, I mean, it's the reality.
No, it's a good point. Actually, it's a good point.
Yes. I'm not saying that there's no way to do it. Yes, as I have said, we can do it, but I think that it should be clearer in the legislation.
I was thinking also, for instance, warehouse cannot limit their liability. And actually, if a massive fire happened on a warehouse, it could be, you know, pretty bad. So that's actually is a good point.
That's my point of view.
Yes, but you must see that who takes the advantage of the activity. Normally, who takes the advantage of the activity bear the risks of this activity. Normally, just like in the maritime field, we have limitation of liability because the risks are too high and concentrated in a ship owner, and he cannot bear all these risks because it'd be hard to develop this kind of activity. So what, Carl, what do you have to say?
Well, it depends, because when it comes to terminals, when it comes to warehouse operators, when it comes to ship owners, you base yourselves on a contract of carriage, on a contract of storage, on a contract of operations. You contract, and in that contract you can basically agree on limitations of liability, and most of the times this is the case. I think when you're operating a terminal or a warehouse in Belgium, almost always you will be able to limit your liability, even though you're basically profiting from the activity you're basically doing. And I don't think there's a problem with that, because the conditions have been agreed upon in advance. The only reason why you sometimes need intervention in those parties' interests by means of treaties, for example, on limitation of liability, is because there's no contractual equity. You're not having the same weight in contract negotiations, especially when you're shipping stuff on board of a liner vessel from MSC, from AP Møller-Maersk. You won't have a say in negotiating, yes, okay, I want my goods on board of your vessel, but can we have a discussion about the limitation of liability you will apply? No, those are the terms and conditions. You will accept them or you will not have your cargo on board. So there is a need, some regulation, I think, but not too much. When it comes to terminal operators, warehouse operators, I think it's defendable that you can contractually agree on limitations of liabilities. Exclusion for misconduct or gross negligence or anything like that is a difficult point, is a contested point, and will, in most jurisdictions, as far as I know of, that will be excluded. So you won't be able to exclude your liability or when you're grossly negligent, or when there's willful misconduct.
We have a way of overtaking the limitation of liability. We are not obliged to have the limitation of liability applying in a contract because we can have the threat ad valorem. It means a declaration of the real value of the goods transported. You can make this declaration. So the limitation of liability won't apply to you if you make this declaration. Of course, we are going to pay a high amount of threat for the ship owner, but the limitation won't apply in these cases. What about you, Masaki? What do you?
Generally, in Japan, it's discussed with the development of the transport system and the more complex and each players try to limit liability. Of course, they do not want to bear huge risk. So we tend to look to the insurance, which means the insurance is very important for all parties. So that's why the insurance company are trying to adjust the insurance policy to adjust the development of transport system.
Okay, so let's just talk about the last topic of the second point. Can the pilot be liable for damage caused by the ship?
I think this one is a big issue, actually, because the investigations are still ongoing. So being, for instance, the P&I club, the marine liability in insurance of the owner, they probably will argue that the pilot of the Suez Canal Authority will be at least contributory negligent. So about the pilots, it depends also regarding the internal regulation, the internal legislation. I'm not really prepared on Egyptian law, but for instance, in Italy, pilots have a contract with the owner. So he became part of the crew, but there is a different doctrine about that. So on the one hand, we have the pilot, which is part of the crew, so master would be liable. On the other hand, someone say, no, it's not to the end of the liability, but just for the hierarchy within the vessel. So pilot can be held liable in some cases. I don't know in this one, the ever given, but probably can limit as well his liability. In Italy is up to 1 million is limitation of liability. They got also a compulsory insurance for negligence. So that one actually is a big issue, not only regarding the liability to exclude owner liability or to be contributory negligent, but also because a question that we should ask can be, for instance, a pilot can render the ship unseaworthy if he refused to work. I don't know actually how things went in the every given case, but pilot might be a bit liable. It depends on what actually he did.
I think there is a bit of nuance to be made when it comes to pilot liability, because on the one hand, piloting is an activity which can be managed by either a public authority or a private company. Piloting can be privatized, like you have public transport or private transport companies. For example, in Belgium, piloting is managed by the public authorities, by the Flemish region. In the Netherlands, which is just next to us, and they basically have the same pier from which they depart, that's a private company. So that is a different constellation to begin with. Now, what you see in many countries' legislation is that a pilot is to be considered as having an advisory role to the master. So a pilot is not someone who takes over operation of the ship. That responsibility mainly lies and stays with the master of the vessel. So when a pilot comes on board, it can be that he's taking over steering and navigation of the vessel, but that will be under the supervision and the responsibility of the master. In that case, a pilot should give proper advice, but when something goes wrong, the master is the one who knows his vessel, who knows what his navigational speed is, who knows how his vessel is reacting. So when something goes wrong, in principle, you will not definitely look at the pilot. the pilot may give directions which are clearly wrong and causing an incident, and then it is up to the ship owner to direct a claim to the pilot, to the advisor. He was sometimes, yeah, compelled to take on board, because sometimes piloting is compulsory. So when that happens, liability of the pilot will be limited in most cases. In Italy, for example, yeah, it's 1 million. In Belgium, it's basically a joke, because the liability of a pilot who is grossly negligent or willfully misconducting is 10,000 euros. When something goes wrong on board of a vessel, you can't even repaint a part of your vessel for 10,000 euros. So it doesn't cover anything. And the result is that in practice, you will almost never direct a claim against the pilot, because for 10,000 euros to fight a legal battle, it's not worth it. No one will do that. But that is the Belgian case. And there is a conflict of interest as well on that front, because when you have a pilot who has been grossly negligent, who has made a mistake, but it is basically a public agent, it's someone who is appointed by a public authority. Public authorities have their own budget, and that is directly linked to the legislator, because in Parliament will not pass a law that exposes the states to a huge liability. So in Belgium, for example, the amount is 10,000 euros, just because of the fact that it's part of a public authority. When something goes wrong, basically the Belgian state is liable, and to protect themselves, the liability for pilots is so low. Also personal liability, there can be criminal misconduct when you're basically as a pilot intentionally steering a vessel towards another vessel, or towards a quay or a crane in the terminal. Yeah, you can be criminally liable, but that's a different matter. Then you're not really liable as a pilot. You're liable based on criminal law. That's a criminal offense, because you can create loss of life or injury to people or to entities. So but that's a different matter.
And Masaki, what about your point of view?
Okay. In Japan, Japanese jurisdiction, we have the similar position of Belgium, and unless the claimant can prove willful misconduct or gross negligence of the pilot will not be liable for loss of damage of the incidents. And additionally, the liability of pilots can be limited. So that's why we have the similar position of Belgium.
Okay, thank you very much, Masaki. And we are gonna go to the third topic about P&I clubs. It is known that in the event of an oil spill at sea, civil liability convention guarantees the possibility for a victim of pollution to file a lawsuit directly against the P&I club or another party identified on the certificate as insurer. Making a comparison, in the ever given case, container ship, do you see a possibility for the victims who were prevented to cross the Suez Canal, or for example, as Carl said earlier, the Egypt country who also suffered major damages, can they file a suit directly against a P&I club? Yeah. It's okay, the question, or?
Yeah, yeah. Let me say something really, really fast, because the reason lying on the direct action against the P&I club, it's okay, related to international convention, which actually provide that. not only the pollution convention, but also the Athens Convention, for instance. On the other hand, we need to look inside internal legislation. Because, for instance, if legislation provide compulsory insurance for civil liability or marine liability, so this actually can give the opportunity to, whenever is offended by the marine adventure, may file direct action against the BNI club. I think in the European Union, we got some precedents about from the European Court of Justice about the direct action against the PNI club, apart from Athens Convention or Oil Pollution Convention. So I have no idea about the Egyptian court, or if they provide like something as a compulsory insurance for civil liability in marine adventure. If they have, actually they can claim directly against the PNI club, in my personal opinion.
Okay, Yanni, can you give your point of view?
Yes, sure. Well, in this case, I must confess that I'm not very familiarized with the PNI clubs. However, I will say that as long as Ettore said, as long as here, for example, in Mexico, when you have a civil liability, you can go directly with the or you can bring an action directly to the insurer. So yes, in this case, I will say yes, but in this particular case, we will need to analyze the legislation to which this is subject.
I agree.
Yes. But yes, under Mexican law, yes, you can go directly.
What about you, Carl?
Well, I think when you want to direct a civil liability claim against a PNI club, that will mainly happen under guarantees. For example, in case of the ever given, general average was declared, and you will have most of the expenses covered by general average. So parties will contribute. General average is a principle that is basically implied in a contract of carriage on board of a seagoing vessel. And when you have a case like that, it's almost automatic that you ask for guarantees. Cargo insurers provide guarantees, PNI clubs provide guarantees. So you can basically execute those guarantees, like address people based on those guarantees, but I don't think that will be contentious. If you want to bring an action against PNI clubs, it depends on national law, I think, as Janine said. So I wouldn't be able to comment on that because my knowledge of Egyptian law is very, very limited. The only thing I know is that a pharaoh is not the head of state anymore, but apart from that, no, but yeah, I wouldn't be able to comment on this particular case. So,
Raphael, if you allow me, I would like to ask just to bring this topic to the table. And as Carl said, the ever given declared general average, but I would like to know if for you, this situation constitute a general average act.
That is a very good question. It's very contentious. The first response would be probably yes. But in order to have general average, you have to have an unforeseeable risk or an unforeseeable expense or a sacrifice that has to be made. And the question is if that is the case, because well, when you run aground in the Suez Canal, you're obviously not taking into account at the start of your voyage that this will happen. So you will have general average. But the pickle in this instance, the angle in this instance is, was that ship in danger? Because that's not certain. It was basically aground in the Suez Canal. There was delay or anything, but it was not sinking. You could dig it out and move on. But it's not certain that that ship would run aground or was in a particular situation of danger. And I think that will be a subject for litigation. I think there's a lot to say for both sides when it comes to that argument, and I'm almost certain that that will go to courts and that will be subject to litigation. So my feeling would be that it's possible to accept it as general average, because without further measures, you will probably not be able to complete the voyage as intended. Without making sacrifices or expenses, that ship will not liberate itself magically. But the question is whether or not it was in danger, and whether or not, for example, it wouldn't have been more cost effective to just lift the cargo of the vessel. You need the operational capacity to do that. So it wasn't lying in a terminal. But I think if it would have been possible to transship the cargo onto other vessels or barges, and thus lifting the vessel up because the weight was reduced, that may have been a more cost-effective solution, not for all the other economic interests, of course, because that would have generated more and more delay. But the question is that a consequence of a situation of danger that basically justifies a declaration of general average? And that remains to be seen.
Yes, that's my point. But because to what extent the common adventure, and I'm not talking only about the ship, but also about the cargo, to what extent was this also in danger? Based on the doctrine, the sacrifices made because of a danger or a risk that affects only the ship, but not the cargo, I think cannot constitute a general average. So in this situation, was it that clear that the cargo was in danger to declare a general average? I think this is my point, and this is the question to know whether this constitutes a general average.
Well, that's a good point. But when I'm a cargo interested party and I have 3 containers full of marble statues on board, if those marble statues are delivered to me 3 years later, I'm not bothered. But when I have 20 containers of kiwis on board, yeah, those kiwis in 3 years' time will have deteriorated. So for some cargo, you could possibly say that delay is a risk and is basically constituting a risk to the detriment of the cargo. So that cargo would be considered in danger, but that certainly doesn't apply to all cargo on board of the vessel. So it is, yeah, it is a difficult question, because not all cargo is the same. And what can be seen as enough cargo in danger to consider expenses to the benefit of the common voyage? That's the question. So
exactly. That's the point.
And unfortunately, it's not clear. That's the answer. It's not clear at this point.
Okay, thank you very much. Masaki, do you have something to say, or it's okay? We can
it's okay. Yeah, it's very difficult question, interesting. I have no idea. So yeah, I agree with Carl and Vianney. That's it.
Okay, so let's start the questioning, or do you have something to?
Sorry, Raphael, can I add not a consideration because I'm not a person for doing so. I would like to add another question to Carl, that is the expert of the average situation here. So, but do you think that the general average system should be renewed? I don't know if, because it's a really, really ancient institute. So do you think that we need an additional renew?
I think certain aspects of the general average system are not up to date anymore. But I think as a principle, it's possible to keep it. The problem, and that basically links back to the first topic as to giant vessels and containerization, is that when you have a vessel with 10,000 bills of lading, the adjustments become more difficult to make. You have more interested parties, you have to gather way more intel, way more information to basically make the adjustment and to divide the contributions amongst all parties. But that's basically the job of the adjusters. So we're having more work. That's it, and that's not the point, because you can do that. That's basically a bookkeeping exercise. But apart from that, it makes general average more costly because there's a lot more work going into it. And the question is if that can be justified, because often when you have an engine fire or anything, the costs are not that high. But when you have to make an adjustment for 20,000 people, that's almost undefendable, because you will have to make such a difficult exercise that generates so much workload and costs a lot of money that sometimes the price for having an adjustment and gathering the contributions will be so elevated that it's almost equal to the repair costs or to the expenses. Well, it's a bit an exaggerated position now, but it's a question that has to be asked. Apart from that, recourse actions are a problem in my view too, because when ship owners from container vessels gather contributions on cargo from cargo interests, they do so, and basically the principle in Rule D of the Orcantrop rules is that no questions asked. You have to pay up first, and if there's a contentious position, or you feel like there's fault on one side or the other, then you'll have to reclaim basically claim back your contribution from either ship owners, either charterers, either cargo interests who haven't declared dangerous cargo, for example. And that can be a pickle, because once again, like for piloting cases, if you have a container with a value of 20,000, you have to pay 10,000 of contributions. For an amount of 10,000 euros, you will not bring litigation, for example, before an arbitral tribunal in Singapore or in London, because it's not worth it. And if you have 20,000 small cargo interests who have the same problem, there's almost no way to consolidate themselves. It's almost impossible to gather them and to bring, some sort of class action with 20,000 people addressing themselves to a liable party, like a cargo interest who hadn't declared dangerous cargo, a master who has made a mistake, or an engineer on board of the vessel who has made a mistake. When you have a breakbulk vessel or a tanker vessel, you have one or two cargo interests, and they will basically address a claim or a recourse action. But also, when the owners have a charterer, the owners claim contributions in general average, and it often happens that they basically direct the claim towards the charterer as well. The charterer and the owner have litigation, which is confidential, often in arbitration. And when that is the case, the owners can do two things. They can basically claim from the charterers as well, because charterers don't really know whether or not contributions have been collected. Secondly, when they're not doing, well, when they're doing that, owners can basically swing by the cash register twice. When they're not doing that, and that's another possibility, they can basically protect their charterers against recourse actions from cargo interests. So they have a contractual relationship with their charterer that can be a good relationship, and in order to protect their charterer, they can basically shut down all communications as regard recourse actions with the cargo interests once they have collected their contributions. And I think that is a bit of a loophole, because cargo interests and cargo insurers don't really have a mechanism to pressure owners into bringing recourse actions against a liable party. And I think on that front, I think there should be some mechanism that basically unites the common adventure, because general average is basically a common interest. Everyone has to pay, but I think that should go together with a common interest in bringing recourse actions and also consolidating that, because if that's not happening, you're basically paying the contributions and that's that. There's no way to hold people accountable, at least not for smaller parties, and they are numerous on big vessels, on container vessels. That's a consequence of containerization and containering on giant vessels.
Okay.
Thank you, Carl.
Really nice. Do we have another question? Because we must stop within 7 minutes. So, Professor Dominique Gaurier.
I've no question about all your discussion, because I have no knowledge on positive law at all. I am only an historian, legal historian. But I can, however, recall for the interested persons that I translated from Dutch an old treatise from the 16th century of Quintain Weitsen, Traktaat van Avarije. And I translated it into French. And I wrote also a chapter in my Roman maritime law on the Lex Rodia de Iactu, which states the the principle of general averages. That's all what I can say about that.
Even though Dominique, it's good to see you, and it is really good to hear you. Do we have another question? So I will pass to Hama.
I see there is a question in the Q&A.
In the Q&A, sorry.
From Pierre Merer, and if I remember correctly, we met each other in Hamburg in 2019. So hi, Pierre. So the question is, a practical hurdle on bringing a direct action against the P&I club is that most of them are based in England, now officially outside of the EU. All of the P&I Club rules provide for protection against such actions under English law. Does any of the participants believe an action filed in their jurisdiction would allow to hold a P&I Club liable? Enforcement of such a decision would still be an issue, however. So, if I understand correctly, your question is whether or not EU countries, for example, or Japan, for example, or Mexico, would consider themselves as unable to receive litigation with an enforcement clause or with a jurisdiction clause referring to English law. That was decided by some principles of the Brussels I bis treaty before the UK left the European Union. UK is not bound anymore by that treaty. So I would say, but I'm not too sure on that. I would say that basically there's no jurisdiction whatsoever anymore, and that can be contractually excluded. But I'm not sure if that applies. I'm not sure whether the most recent developments as regards the applicability of such clauses are.
Okay, Hama.
Yes, thank you. It was a very good conversation, and I would like to thank you everybody for this participation.